All right. That issue then is whether the court should grant the defendant's motion to dismiss based on many grounds that he's raised, and it makes it very difficult for us to make a very good record about these issues because he's raised so many issues, and makes it, again, as I said already, difficult to try to fashion a decision that addresses them all. It's clear, obviously, it's undaunting for anyone, including Mr. Barker himself, to understand the process. It's not only legally complicated, but factually complicated. This case is factually complicated by the fact that there are multiple search warrants used to try to recover evidence that relates to this matter and the charge against him. The issue of whether a search warrant was valid or invalid is a legal issue, is decided by the court. He is arguing various deficiencies of various search warrants, the lack of probable cause on the facts of the search warrants, and so on. It's almost like a shotgun approach. Really the only thing that matters in this case is the validity of search warrants that were used to recover evidence that will be used against him in this case. And filing all these search warrants and all these documents makes it just confusing, trying to figure out which ones are relevant, which ones are not. It's difficult when we have a process that is something we expect a layperson to understand when they're not involved in the process. When we have a complicated flow of paper that relates to how search warrants are managed by the clerk of court's office. We know that when search warrants are executed, there isn't a case file charging someone with a crime that exists. And so what the clerk of court's office has to do is to devise a system to accept these papers, because the law requires that within a certain amount of time after a search warrant's been executed, that it be returned to the clerk of court's office. And so when the clerk of court's office receives something of that nature, at least prior to the change that was made, when they would receive a paper, they would date stamp it as being received, which adds another complication because it confuses Mr. Barker when he sees a date stamp and he thinks that that's the date that it was filed with the court. He's confusing. Stop objecting. I'll note a standing objection to everything here. I'm going to speak now. I didn't interrupt you while you spoke. Now be polite if you would, please, and don't interrupt me, okay?
Yes, sir.
All right. So, and I don't fault Mr. Barker at all. I think it's difficult to understand a process that's administrative and the flow of papers. Terms get thrown around and get mixed up and confused. We know that there is, again, a massive search warrant file that the clerk's required to keep because they have nowhere else to keep them. They have to keep them. The law requires that they be returned to the clerk of courts. So they do that by putting them in this massive file. And Mr. Graziano has testified about how the system has changed in the last several years to manage that better because of the numbers and so on. But they're now filed by date, and by the date the judge signed them. If they put information into the computer about what's involved in the search, maybe an address or something that might help them find a search warrant, if they have to find it to tie it to some other proceeding. We also know that there are cases where search warrants are involved in a criminal matter, at least in my tenure as a judge, where the search warrant was never even brought to the case because it wasn't an issue. It wasn't challenged. People knew that evidence was recovered by a search warrant, but it wasn't challenged because there was no problem. Perhaps the defense attorney went to look at it, got it, read it, reviewed it, didn't see any problems, and then they didn't want the original in the court file. It remained somewhere else in the search warrant file. So, it's not an easy process to understand. It also is clear that search warrants remain in the search warrant file and don't get to a case file unless a party or someone requests that they be placed there. So, search warrants are, again, received. Whenever a paper is received, it has to be filed. Whenever a paper is filed in the court system, it's now electronically filed, date stamped in the upper right-hand corner. And so we get all these competing systems. We have a system in a law enforcement agency where they are able to do things electronically, and that includes electronic signatures to documents that they might generate. But those documents, again, also have to be filed with the clerk of courts and so on. So it gets to be pretty confusing. It's also confusing because Mr. Barker wants to find fault with everything and is looking for every piece of this case, every search warrant in this case, and that gets to be confusing because, as I said earlier, search warrants only subject to a motion if it contains evidence that was recovered. And some of these search warrants, there's like a list in Mr. Nielsen's letter here of many, and there are many more. But they don't relate to Mr. Barker necessarily. They might relate to a co-defendant. They may not have recovered any evidence that resulted in the execution of the search warrant. And so it gets to be a pretty complex fact-driven circumstance. I guess from what I know from the search warrants used in this case to recover evidence, I find that they do contain probable cause to support the issuance of the search warrants. I think one of them was one I actually reviewed myself as a judge and found probable cause to authorize a search warrant. The other issue that's raised here is whether or not they're properly executed, if you will. And really, I think we get confused when copies get filed that aren't the original and they're not signed and they get floated between people and so on, but I'm satisfied from the record that's before the court that the search warrants that were used here may have had copies out there, but there also was an original that was properly signed and executed. The only issue that is of concern to this court at this point is whether or not the absence of a notary seal is defective, a defect that defeats the search warrant itself. And
Your Honor.
no, I'm talking. Not going to argue anymore.
I'm not arguing, I just wanted to, you missed out on one key point.
The issue about whether there's a seal on a notary's signature or not is confusing on this record. Because if there was an original document that had a seal on it, the copy that's of the search warrant that's relevant in this case in the file, we can't see anything. We don't see any shadow of an embossment. We don't see an embossment. We don't see a stamp, certainly. If there was something there that didn't get preserved because it got scanned into a system, we don't know. So we have to assume that it wasn't stamped. It wasn't embossed, okay? Because no one's produced the original of the document, which I can put my fingers on and rub my fingers across and feel the embossment of a notary seal. So we accept the fact, based on the record here, that the search warrant notary signature did not have a seal, okay? Because no one's produced the original document to show that it had a seal. I think that's something that, the people involved here, in particular the clerk's office, ought to be more cognizant of, because if a scanned document's not preserving the whole record, then they're required to keep the whole record, in my opinion, especially if there's something that might be challenged later like this, where there's a search warrant that doesn't have a seal. However, I'm not certain that that's a defect. The statute itself, 968:22, states as follows: no evidence seized under a search warrant shall be suppressed because of technical irregularities not affecting the substantial rights of the defendant. And I'm looking at the letter that's been submitted, the letter memo submitted to the court by Ms. Johnson, from the Walworth County DA's office, which cites cases where search warrants have been upheld where the affidavit wasn't even signed by the affiant, where there was testimony in the record showing that the affiant thought that they had signed it and made a mistake and overlooked it, but that the affidavit they authored was true and correct. The facts were true. They forgot to sign it, and courts have found those to be basically not defective, but not affecting the substantial rights of the defendant. Clearly, if a signature is missing and doesn't affect the substantial rights of the defendant when not provided, certainly When a notary signs something, presumably the person's sworn to it, but presumably, certainly a notary forgetting to put a stamp on a document is in fact not something which affects the substantial rights of Mr. Barker or defendant. So I'm satisfied that that is not a defect which defeats the validity of the search warrant. So I will find that this search warrant used here and all search warrants referenced in this record are valid, and that based on those grounds, the motion to dismiss should be denied. Regarding spoliation, certainly that is an issue in a case where evidence is lost and not maintained. In this case, there were three statements, I believe, that were recorded, or attempts to make recordings of them were made. And again, the law is clear. Just because a recording was made and may be lost doesn't defeat a case. We have to look at what the recording was of. We have to look at what the recording contained. And clearly, the state's only required to produce what's referred to as exculpatory evidence. They don't have to make